So first up, I have Joshua Floyd versus
Present.
Dana Johnston.
And on Zoom.
Okay.
Judge Rebecca for Ms. Johnson, and she's on the Zoom.
All right. And sir, you are Mr. Joshua Floyd?
Yes, ma'am.
I'm going to place you under oath if you'll raise your right hand. All right, I'm going to begin with some beginning questions here. What is your relation to the property at 8308?
The property owner.
The property owner.
I am property owner, yeah.
Okay. Oh, you guys have the same address.
Well, no, actually, I live adjacent to her. That's my neighboring house. So I live in the house that I live in and also own the property next door.
Property owner. I'm sorry, I didn't see the 06. No,
Yes, ma'am. I'm
quick
sorry.
glance.
A lot of people
quick
don't
glance
because it's
look like
right next to
something.
each other. Yeah, they think I might have messed up on my
I
my
got you.
address, but it's not. It's the adjacent house.
Okay, let me review the face of the complaint real quick. Okay. And you entered into a written lease with Miss Dana Johnson,
Yes, ma'am.
and she was to pay $1,600 by the 14th of each month.
Yes, ma'am.
And you on this say that 14th of each month. Okay, so let me hear the arguments because you're on the face of your complaint. I have some concerns about how it reads because you state that she's failed to pay for 2026.
Yes, ma'am.
But then you say that she has not paid for February. But then you also say that she's never paid rent in full or at any time and never paid late fees. So there's some confusion as to exactly how much you're stating she's behind. And then I need to know, you said you sent a notice to pay or vacate. And what date was that?
I believe it was, I don't know the exact date, but I did.
Well, on your complaint, you gave a date.
Yes, ma'am. Okay.
Okay. You need to hold back there. Miss Cotton, will give you space if you need to hold back there. That's fine. I mean, I didn't know if he was going to fall off. It's under section 4.
Okay, February 6th is when it says that I gave them the notice.
And what did that notice say, sir?
Just pretty much, I want you guys to move out. Y'all
Do you have a copy of the notice?
I do not, no. There was a witness with me when I gave it to him.
You hand delivered it?
Yes, ma'am.
Okay. And then you filed this complaint on February 18th, correct?
Yes, ma'am.
And by your admission, did you give them the opportunity to pay?
Well, I've given them many opportunities.
You gave the notice?
No, ma'am, I don't. Okay. I'm done with giving,
Okay. Okay. Well, I want you to listen really closely to the arguments of their attorney, Miss Cotton.
Okay.
Okay.
Yes, ma'am.
And we'll go from there. Okay.
Okay. Yes, ma'am.
All right. Thank you.
And Judge, we would be requesting to make an oral argument to dismiss the case. I did speak to Mr. Floyd prior to the hearing, and he refused to provide me with a copy of the notice or to speak with me about any kind of resolution. My client will testify that she didn't receive it. There's no proof before the court that this notice exists, and the recitation of Mr. Floyd is absent an amount, absent and a right to cure, and the face of his complaint is confusing as to what specifically he's asking this court to rule on.
All of the above.
No, you can't interrupt her while she's speaking. Thank you so much. I
also believe that it's contradictory on its face, saying that you owe for the full month of the full year of 2026, then saying you owe for the month of February, and then saying you've never paid rent when this lease goes back to 2022. Those statements are contradictory to themselves. So we would be requesting this case be dismissed.
Yes, you may have it. Yes.
I've got text messages, multiple text messages about how they are supposed to pay rent and then do not pay it, and then also do not pay late fees.
Yes, sir.
So I'm not sure if that really matters. And also I have a witness that was with me when I handed her the paper. I can bring him in.
I need the notice though.
No, I don't have it with me. I gave it to her.
Well, you're supposed to keep a copy of it because that's going to be your proof. But by your pure testimony, you also have an issue with what you gave them. If you are saying that you want to terminate and you're not giving them any opportunity to pay, then there's a certain time frame that you also miss because you can't. And then if you're saying that and again, it's inconsistent on the face of on your complaint. If you'll go back and look at it. It reads as if it's actually contradictory. So I don't know if she never paid in 2026 or if she only didn't pay February, but you say February rent's not due till the February 14th, but you gave her the notice on February 6th.
Mine, it just says tenant has never paid rent in full and or on time, as well as never paid late fees.
So it's also deficient because you have to give specific amounts, not Pacific Ocean.
I understand, yes, ma'am.
But you do have to give specific amounts, and then those amounts, I can't tell you how to do it, but I need to be consistent with what you put on the notice. Now, again, a certain notice to completely vacate needs to follow a very strict timeline, and you are well short of that timeline. To pay or vacate is a different timeline. And so you'll need I'm going to refer you back to, there's a flow chart that the sheriff's office has created that will help pro se tenants like yourself. But even without representation, and she's given some different arguments, to face your
I'm
complaint.
gonna have to just hire my lawyer because I don't really understand all this. If my lawyer was here, she would probably straighten it out. I don't have a dime because this is my only income in the winter.
Yes, sir.
And I cut grass, so I'm broke. I got 4 children I gotta take care of, and they know the whole scoop. I live right next door. For the 3-4 years they've been there, there's been 2 or 3 drug overdoses. My children live there.
It does not sound like
it's just a big thing, and I'll just have to get my lawyer. And I apologize for wasting your time.
No, just no.
This is just the first time I've ever done this, and I didn't really know anything about it going in it. And there's nowhere that really tells you. I didn't know of anywhere that tells you about how to really go about doing it. You know what I mean?
Yeah, and the clerks here, they do their best, but they are not allowed to give legal advice. So they can just take what you give. But this flow chart may help you. There are people who can do it without the lawyer. You'll just need to follow some different steps that you failed to do this time.
Yes, ma'am.
Okay.
Yes, ma'am.
So again, I will say this. Let me tell you this. Let me tell you this though. Let me tell you this, Mr. Floyd. Let me tell you this though. Why they have an attorney? It is really in your best interest to speak.
It's a free attorney. I don't have $1 right now,
First
so I
of
don't
all,
have money to hire an attorney. But I will go sell and pawn things that I have to hire an attorney.
Would you let me
to do
finish?
that? Yes, ma'am. Go ahead.
Okay.
I apologize. It just frustrates me. Yes, ma'am.
Again, there's a way in which you can do it without hiring an attorney. You just miss some steps. But even more fruitful for you is if you try to at least have a quick discussion with their attorney before she leaves. Again, a cordial, respectful
Yes, ma'am.
conversation.
No, there's nothing disrespectful about
but
any of
I'm
this.
telling
It's all
you
business. Yes, ma'am.
that business can be respectful.
Yes,
Business
ma'am.
can be
Absolutely.
messy.
Yes, ma'am.
But if it is about, she might be able to say, they want to stay, they're willing to pay, and then she might be a voice of reason since if you guys can't really work anything out.
Yes, ma'am.
And you may just say, you know what, thank you, Ms. Cotton. I'll just try to restart the process.
Yes, ma'am.
But when the attorneys are here, it's a good opportunity to see where your tenants are at.
Mhm.
Okay.
So
For today, I do have to dismiss it. It's
Yes, ma'am.
flawed on its face.
Yes, ma'am.
If you start the process again, everything, you could check all the balances and you could be on your way to an eviction next time. But hopefully, maybe you could resolve it before the filing of any new complaint.
Okay.
Wait, yep. Okay. Go!
Will you hand me my screen box?
Now go. All right. We Capital Furlong versus Katetta Smith.
That is for non-payment.
Ms. Smith?
Yes.
I'm
Good
sorry.
morning, Judge. McKinley Butler for Miss Smith. Miss Smith is on Zoom. Me and the Ron office have been back and forth with trying to get something worked out. I believe that we've settled on just passing it, just a straight pass for a week, to get something more specific from the agencies she's reached out to for assistance to give to the firm, and then return back just after the straight pass.
Okay. Mr.
That
Benz?
offer was taken off the table after Ms. Butler's one email yesterday, Your Honor. The offer Ms. Ron last extended to her was a standard agreement to pay in full or vacate in the week. And Ms. Ron this morning told me that she would add to that if the evidence we're needing for rental assistance was provided within that week, we would then consider extending the standard agreement.
That was not my understanding, Judge. And I also reached back out to Miss Ron to confirm, and she never got back with me.
When you email me at
My client is not
9:40 in the
position to
Hold on
enter
a
a
sec.
standard
We'll make
agreement.
let's just make sure we have one person talking at a time so it's clear on the record. So Ms. Butler was saying that that's not your understanding, then what?
That's not my understanding. And if that offer was taken off the table, then that was not clearly communicated to me. And I reached back out to the firm this morning before court to confirm, and no one ever got back with me.
Okay, let me
All
hear
right,
from this.
first of all, it was clearly communicated. When Ms. Butler accused us of not following our ethical duties and obligations yesterday, Ms. Ron clearly communicated that to her. And second of all, when you email me at 9:36 in the morning when I start court at 9 and have been on here nonstop, you cannot expect a reply.
So we'll pass it for a hearing. We'll go to March 30th at 1 o'clock.
We object, Your Honor. We've heard no grounds for a hearing.
Let me finish what I'm going to say, because this has got to, well, again, the interpretation of the court will now be what was clearly offered, what was not offered, what was rescinded as an offer. If this is the argument that the counselors are making, then bring it to the court. Go ahead, and if you guys want to file anything, we'll do that as well. Because I understand there's been a lot of bickering between some attorneys in here, and I want everyone to fully feel heard. If there was an offer, I'm sure that we can get that clearly presented, but I do know that everybody has partners that they work with. Mr. Benz works with Ms. Ron. Ms. Ron works with Mr. Benz, and they relay their, information and their understanding to each other. The court just needs to understand it as well. And then we'll decide. I'll need to make a decision to me, if there's more going on. I'm not going to do this on this docket at this time. If there was a pass, because then again, I didn't ask you to put on record all the information about the pass. I understand there's some discussions about whether or not assistance is being offered, but again, we'll have to try to be cordial. Colleagues, everyone's of the bar here, and we'll go to March 30th at 1 o'clock for the hearing.
What are the grounds of this hearing, Your Honor? Because I've heard no defenses that they've raised that would give them the right to a hearing.
The hearing that I went ahead and set it for, because you have both now said that she said there was an offer extended. You're saying it was rescinded. We're going to have a hearing on offer and acceptance.
I'm allowed to rescind that at any time, since there was never a formal agreement and never a meeting of the minds. We would, if they're wanting to argue this, I just want to move forward today, because there's no grounds for a hearing over whether there was settlement discussions, because settlement discussions in themselves are not admissible in court.
I agree with that, but I'm going to tell you right now, there is an issue that is going on, and you're also saying if they've accused you of ethical, you have.
I have that in writing from her.
Right,
He's
and so you have
me
the
of
right
things as well, Judge.
Right,
and
I'm going to tell you right now, Judge Langford and you're going to have to put a nip to this. We're really getting concerned about some of the bickering between that's going on. And
I'll be glad to discuss it with Your Honors and legal aid, since they have started this war.
I'm not here to, again, that's another accusation that, again,
that's a fact.
That is part of the issue that the court is seeing in this court. And again, and I'm just going to put on the record, it might be right for a time for you to assert some different interaction. But again, for as far as the purposes of this case, it's just really starting to get to be an issue. Okay.
This put on the record, our objection is there's no grounds for a hearing on with whether settlement agreements were discussed or not, since it's not admissible, and that we requested to move forward today, and that was denied, even though it was our right. That's
fine, Judge. I'm listening to you. I'm not taking orders from Mr. Benz. I'm just doing my job. And
objection, Your Honor. She wants to make snide little comments.
No. Stop interrupting.
I'm allowed to object when she makes a snide comment.
You've made snide comments too. This is the part of the issue. This is part of the issue. You guys are both lawyers. There's people who are not lawyers in here watching you two act like this. No offense, but I'm telling you both right now, you guys went to law school. You know to let the other party finish speaking. It's not an evidentiary objection. You don't need to interrupt her. So stop interrupting each other. Okay? And again,
we'll agree to disagree on whether I'm allowed to object when they make personal attacks, Your Honor.
But again, we're also allowed to disagree whether or not you should take it as a personal attack. No different than, again,
I take everything from them right now as personal because of their behavior.
We could do the same, but Judge, again, I'm trying my best.
Again, Your Honor, snide comments.
Well, again, you interrupted her again, and she didn't interrupt you. And you've made snide comments and she didn't interrupt you. Okay, so my understanding is, I understand you said there's some discussions, rental assistance, um, objection to going forth because no grounds for a hearing. I'm just noting it for the record. Thank you, Mr. Benz.
We would also note as they've raised no defenses today, Your Honor. All defenses are waived as they needed to be raised at the first call.
Rental assistance was discussed. And did you ever speak with Ms. Ron?
Yes, just
Okay.
through email.
And through email though?
Yes.
So that's okay. Was discussed via email.
Yeah, it was back and forth between Mr. Benz,
Ms.
Ms.
Ron.
Blackmer, and Ms. Ron.
Okay. And again, I will agree with Mr. Benz that we're not going to get into the substance of the settlement negotiations, but there is going to be an issue with this ongoing bickering between certain parties that the court is need to put in, going to need to put it into. Ms. Blackmer and Mr. Benz.
And Judge,
Good
may I
morning.
say something when I get the chance, when you're ready?
Substance of settlement is not to be discussed. And I'm just noting, I agree with Mr. Benz on that. And then I'm gonna let you say something. I got one more thing to say. Go ahead.
I could go toe to toe with Mr. Benz on the allegations of he said, she said, back and forth.
Objection. This is
You do
irrelevant.
not,
Move to
Mr.
strike.
Benz, Mr. Benz, do not interrupt her again. Just refrain at this time from interrupting. Okay, thank you, Mr. Benz. She didn't. Thank you. Go ahead.
I'm very confident that I haven't done anything wrong. I haven't hit the ball. I've submitted what they've asked for. I've been honest about what I can't submit for my client based on the rental assistance agencies not getting back to her at the point that she's at with the application process. It's not that easy, but she's made multiple efforts. I've sent long, detailed lists of what she has done and what she does have to offer as of now, and simply asked for it to be for more time for her to get it figured out. And then when that was addressed for the week for her to get time to get something in writing, I understood that. We went back and forth as attorneys do in negotiations, but respectfully, I'm not one of the attorneys at Legal Aid that is going to go back and forth with Mr. Benz if I don't have to. I'm trying to do my job, and I don't want it to be framed as me just bickering with him, because I'm not the one to do that. But I'm also not going to let him bully me in front of the court and in front of my client for the sake of my client.
Okay, thank you.
Your Honor, that last comment she made was totally inappropriate and uncalled for.
That's not for you to judge. That is not for you to judge.
And we would move to strike it.
There's nothing.
Second of all, Ms.
Not.
Butler fails to acknowledge that she accused us of an ethical violation because she accused us of not sharing her offers with our client when we had done so.
And I'm prepared.
That is why there became an issue, is because Ms. Butler overstepped and accused us of violating our ethical obligations with no proof and no allegations. In fact, Ms. Butler's behavior and such is
Don't insult people. Listen, don't.
I was just saying the behavior was reprehensible and it's subject to reporting to the bar.
I haven't heard anything reprehensible, or that, and again, maybe you have it, but not today. I haven't heard anything as such. Again, there is one thing about zealous advocacy, of which you both should be doing for your clients. That is par for the course. Again, I'm not going to go further on the record at this time about, behavior that is consistent with other complaints between these two offices from both ways. And again, you guys, hopefully you'll figure it out. But I will say this, words have meaning. Interpretation has meaning, but at the end of the day, I'm going to sit in my job and be the mediator and be the arbitrary, because I do not feel like, besides the accusations that, and again, she's feeling bullied or does not want to be bullied. Again, you're feeling that if there is duty of ethics that she has presented, you feel that somehow that is a personal attack. I don't think you should feel that way. You're an attorney. There are certain lingo and language that is par for the course. We will continue this to March 30th at 1 p.m.
Your Honor, they're not the only one that feels bullied. I feel bullied when it took 8 of them the other day to make one argument against me, and they continue to personally single out and attack me.
Well, and like I said, I wasn't privy to a lot of things, but it is starting to be an issue that I think we should address so everybody can continue in their jobs.
Like I said, I'd be happy to sit down with your honors and legal aid to discuss.
And Mr. Benz, you have a thriving business. You're very knowledgeable. Ms. Butler is what I would consider a rising star at legal aid. I mean, she is, you know, passionate about advocacy as well. There is room for everyone at the table.
Thank you, Judge.
Okay, so we'll go to March 30th at 1 p.m. That does, and again, you don't have to continue discussions, but clearly that is a good opportunity. And then I really do think we could start just moving on from some of this so everyone feels heard. But this is really also about your clients. Okay.
Thank you, Judge.
Thank you so much.
Just again, Your Honors, they raised no defenses today. We consider them all waived.
Well, again, hopefully you'll have an opportunity as everyone to discuss and see if you can seek a resolution before the hearing. Because again, I'm also, this is the last thing I want to say. I want to speak with my chief and just try to get everyone on board about what is the best thing that we can do to continue to lower the boiling point with some of the matters that have been brought up. I think everyone has an opportunity to be in this court. Everyone should be heard. And we should all be striving to follow the law. So this is kind of bigger than just Judge Lakefer and I at this time, that we really want to make sure that we're just on par and that we're doing our best to continue with the advocacy work that both of you are doing. And
Is
really,
Judge Moore still chief?
who?
Is Judge Moore still chief?
Yes, sir.
We would ask for a neutral party other than Judge Moore.
Well, she's our chief, so I don't know. That's for me to discuss. I'm not saying she should be present, but she is definitely our chief. I don't know what. And again, I don't know why you
There's
feel
history
she's not
there.
neutral. But she's still a judge. So let's just show that respect. Okay, it's March 30th at 1 p.m. Just write down for me. Just write. Okay, just start. Okay.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot spread myself from.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in first. We're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
No case there. I grab my bag and hit the dash. I'm the one that needs a drink.